Question: what does being charged with an offence mean? In short, if the police believe an offence has been committed and believe that you committed the offence, you will be charged with the offence. But let me make 10 points to explain further. 1. Being charged does not mean that you are convicted and guilty of the offence. You are still entitled to a fair trial and the presumption that you are innocent until proven guilty. 2. The decision about what you should be charged with rests either with the custody officer or the Crown Prosecutor, normally depending on how serious and complex the case is. 3. The decision whether to charge you with one or more offences is made by applying the Code for Crown Prosecutors, which sets out the general principles prosecutors should follow when deciding whether to prosecute a case. The full code is a two-stage test. 4. Stage 1 is known as the evidential stage, where a prosecutor considers whether they are satisfied there is sufficient evidence to provide a realistic prospect of a conviction for each charge against you. In other words, if each charge against you proceeded to a trial, a magistrate or a jury would be more likely than not to convict you. The prosecutor must make a decision in this stage considering whether there are any lines of inquiry or evidence still outstanding. An objective assessment of the evidence, including whether the evidence is reliable and credible, and the strengths and weaknesses of the defence you might put forward. 5. Stage 2 is known as the public interest stage. If the evidential stage is satisfied, the prosecutor would then consider whether prosecuting you would be in the public interest. So, for example, the more serious the offence and the culpability and the harm alleged, the more likely it is in the public interest to prosecute you. 6. In some circumstances, instead of the full test being used, the threshold test is applied where, in the opinion of the police or Crown Prosecutor, you present a substantial bail risk and not all the evidence is available at the time when you must be released from custody until charged. It can then be used where there is insufficient evidence to meet the evidential stage of the full test, but there is a reasonable suspicion that a crime has been committed and further evidence can be gathered to provide a realistic prospect of conviction. 7. There are two ways you can be notified of being charged. The first way is by way of a formal charging process at the police station, usually following a police interview under caution, followed either by bail to attend the magistrate's court at a later date, with or without bail conditions, or a decision to detain you to appear before the court on the next working court day. 8. The second way is by way of a requisition by post, a type of summons to appear on the date set out in the letter. 9. Whether you have been charged at the police station or requisitioned, you will receive a charge sheet setting out the offences for which you have been charged with. And 10. Get a good lawyer to give you professional advice to proactively negotiate with the police a no charge, an out-of-court disposal, or a lesser charge, and to effectively represent you if you are going to court. Feel free to comment, follow, like, and share.